Case 15. Inman versus Air Tractor Inc. We find ourselves in the Florida State Court system once again at the District Courts of Appeal. The facts. Having had his negligence complaint dismissed on 2 grounds, the plaintiff appeals both an adverse summary judgment and the dismissal order. He argues the trial court erred in applying the applicable statutes of repose and in dismissing the action as a sanction for violation of multiple court orders. While the plaintiff was dusting crops, the right wing of his airplane suddenly failed. The plaintiff was injured and the plane was destroyed. The airplane was not considered airworthy at the time because the plaintiff had failed to obtain a required annual inspection. 2 years later, the plaintiff sued the plane manufacturer. He alleged the crash was caused by a defective wing assembly and a factory modification kit manufactured and designed by the manufacturer. The plaintiff specifically claimed that the plane's right wing cracked at the lower spar cap. The plane manufacturer ultimately moved for summary judgment based on the 18-year federal statute of repose and the 12-year Florida statute of repose. The primary issue was whether the plane's manufacturer's design and sale of a new part for the wing assembly in 1993 restarted the respective periods of repose. The record established the following facts. The plane had been manufactured in 1982. The plaintiff purchased the plane from a third party in 1998 with no warranty. The airframe was originally rated with a usable or safe life of 5,000 hours. More on the term safe life later. So what's the issue? Whether the trial court erred in applying the applicable statutes of repose and in dismissing the action as a sanction for violation of multiple court orders. The holding. The court found no error and affirmed. Here's the reasoning. Let's first define some terms. A statute of repose, sometimes called a non-claim statute, like a statute of limitations, is a statute that cuts off certain legal rights if they are not acted on within a specified deadline. A statute of repose is distinct from a statute of limitations, though their effects are very similar. Deadlines imposed by a statute of repose are enforced much more strictly than those of a statute of limitations. In contrast to a statute of limitations, a statute of repose is designed to bar actions after a specified period has run from the occurrence of some event other than the injury which gave rise to the claim. Congress passed GARA to curb the enormous product liability costs imposed on manufacturers of general aviation aircraft. GARA provides no civil action for damages or death or injury to persons or damage to property arising out of an accident involving a general aviation aircraft may be brought against the manufacturer of the aircraft or the manufacturer of any new component, system, subassembly, or other part of the aircraft in its capacity as a manufacturer if the accident occurred after the applicable limitation period 18 years, beginning on the date of delivery to the aircraft to the first purchaser, if delivered directly from the manufacturer, or the date of first delivery of the aircraft to a person engaged in the business of selling or leasing such aircraft. The safe life of an airframe represents the maximum number of hours the airplane can be flown before the accumulated stresses of ordinary flight make continued flying dangerous. If on a particular aircraft the first fatigue critical location, FFCL, can be modified or replaced and thereby increase the safe life of the FFCL, then the safe life of the entire airframe will likewise increase by the same amount, not to exceed the safe life of any other airframe component. Here, the plane manufacturer's president, who had also designed the plane, agreed that the FFCL on the plane is the outermost of the 4 bolts on the spar splice. The spar splice connects the right wing to the left wing at the airplane's center line. The spar, including its lower spar cap, is an original component of the plane. The lower spar cap on the right side fractured in the accident, resulting in the wing separating. The trial court granted the motion for summary judgment, finding that the service letters and inspections referred to in the complaint did not toll the applicable statute of repose. The court also rendered an order dismissing the complaint as a sanction for violating numerous court orders. On appeal, the plaintiff argued that the trial court erred in granting summary judgment because the design and manufacture of the replacement 5-bolt spar splice restarted the repose period. Furthermore, the plaintiff argued expert testimony established that the defective design of this new part caused the crash. The plane manufacturer responds that the plaintiff sued over an alleged defect in the plane's wing, which was over 20 years old and beyond the statute of repose. The plane manufacturer further argues that any modification to an original part does not restart the statute of repose. The Fourth Circuit Court of Appeals had de novo review of a trial court's application of a statute of repose in a products liability action because it involves an issue of law. Section 2 of GARA, known as the rolling provision, states that an 18-year repose period must be applied separately to any new component, system, subassembly, or other part which replaced another component, system, subassembly, or other part originally in or which was added to the aircraft. However, the language of the statute, including component, system, subassembly, or other part, is not accompanied by any modifier or reference to design, thereby indicating that replacement means replacement of a physical item, that is, a piece of hardware, and not a new intangible concept or design. The rolling statute of repose applies only with respect to a new item that replaces an original item. Modification of an item, whether it is a component, system, subassembly, or other part, does not restart the limitation period under GARA. Service bulletins do not constitute a new part and do not qualify under the rolling provision of GARA to extend the repose period, as one court wrote. Given the continual issuance of service bulletins pertaining to a variety of topics, if the statute of repose were triggered every time a service bulletin was issued, the intent of GARA would be eviscerated. The court agreed with the trial court that the 18-year and the 12-year repose periods did not restart with the replacement of the 5-bolt spar splice. Although the plaintiff established a new part was installed, it did not replace an item, but rather modified the original design. Further, the plaintiff failed to demonstrate that the new part actually caused the accident. The court therefore affirmed the summary judgment in favor of the manufacturer, and because it affirmed on the statutes of repose, it did not need to address the alternative basis upon which the trial court dismissed the plaintiff's complaint.